Hi class, so I did my paper on contracts. In the paper, you'll learn about the history of the contracts, contract formation, types of contracts, and the Preston versus Fair case. To begin, contracts did not really come about till the 19th century, and that is when judges hesitated on even making them a thing. They did decide it was time to make changing conditions. They put together a bunch of contracts to help create and modernize capitalism. Not just economically involved, but culturally involved too. To go on, contracts came about when the world was becoming more industrial involved. They ended up being a necessity to the everyday life, and contract law was created. It performs three economic functions in which it helps maintain incentives for individuals to exchange goods and services in a proficient way. The next thing it does is reduce costs of economic transactions because parties don't want to put themselves through things that are already common sense to humans. The last thing contract law performs is that it shows parties things that have happened before, making it easier for them to go about with their activities more carefully. Next thing I talked in my paper was how contract formation works. Most of the time, a contract is governed by the state common law, but there are times when a certain part of the contract may be different in other states. The state statutory common law, which is when things are based off by a judge, and private law are all what contracts are governed by. The private law principle is when parties are making an enforceable promise. The private law tends to not follow all the rules of the statutory law, and sometimes when making agreements will override them. Unlike the common law, the statutory law needs contracts to be in writing, meet certain requirements for the contract to be enforceable. In my paper, I touched on deeper research for the elements to go through. Start with the offer and acceptance, and the acceptance must be mirror image of the offer for it to be valid. The offer is something that a party offers to someone else to do in the future. Next we have is consideration, which is the value that lets the parties to enter into a contract. Then we move on to where the party can accept the offer. The acceptance can be expressed through words, deeds, or performance, and if not, it is viewed as a counteroffer or rejection. Lastly, there is mutuality, where the parties have a meeting regarding the agreement and understanding the terms of the contract. We talked about what contract formation is the two different types of breaches. Minor material. A material breach is when the party fails to do something for the contract and the other party ends up receiving something that wasn't what the contract stated. A minor breach of contract is when a party fails to do something for the contract, but the other party still gets whatever the contract said they would receive. After the contract is breached, sometimes the one parties will be looking for remedies from the other. They are usually monetary, expectation, and consensual damages that a party could recover. There are 8 different contracts you can get involved with, and it would all depend on your scenario. There are express and implied contracts. When you think of a contract, you most likely think of an express contract because they are the ones that are open and expressed in either writing or orally. An implied contract must be inferred by actions, facts that would indicate a mutual intent to form a contract. Bilateral contracts are one-sided. This contract only involves one party, and that party is promising to give something or take action. The difference to that would be a bilateral contract that involves both parties. This can be known as two-sided contract, and they are more commonly known. An unconscionable contract is a contract that is usually determined by the courts if it is unconscionable. Contract gives advantages to one side over the other side and is also unconscionable if no mentally able person would sign or no honest person would offer. Adhesion contracts are usually set up in place by someone who has a better deal than the other party, which means that the other party is the one who can accept the contract or not. If you get involved with an insurance company, there could be a point where you form also an option contract, which allows a party to enter another contract with another party at a different time. You will tend to see these contracts take place in real estate and when entering into a second contract that is called exercising the option. There are also fixed price contracts that involve a buyer and seller agreeing on a fixed price for a project to be done. I also talked about the Preston versus Fair case. Alex Fair played Judge Alex in a television show. Arnold Preston was a California attorney. He claimed Fair owed him fees. They were under a personal management contract. Fair stated the contract wasn't valid under California law, and Preston allegedly voted as a talent agent without license. Preston got denied by court and ended up appealing. The parties that were involved with this case had to agree to arbitrate any disputes. With the arbitrator got to determine the legality of the management contract.